Hello, my name is Elizabeth Tidd and I'm the New South Wales Information Commissioner. It is a pleasure to present this new educational tool dealing with the third access pathway under the GIPA Act, Informal Release. As practitioners, you will be familiar with this pathway, and I trust that this e-learning module deepens your understanding of the right to access information informally. This learning module contains 3 parts and a small quiz to test your understanding at the end of each part. Don't worry, only you will see your responses, so grab something to enter your answers onto as you work through each module. It should take about 15 minutes in total, and I'll guide you through. First, we will examine the informal pathway in the context of the whole of the GIPA Act. Then we will increase our understanding of how the informal pathway operates, and finally, we'll work through some of the practical tools to assist you in working with informal release requests. This guidance is designed to meet your needs, and you can stop the presentation at any point and then rejoin when you're ready. In part 1, we will examine informal access in the context of the GIPA Act. That approach allows us to compare this pathway to the other 3 access pathways under the GIPA Act. Let's just refamiliarise ourselves with the 4 access pathways. 1, mandatory proactive release under Section 6 of the GIPA Act. 2, authorised proactive release under Section 7 of the GIPA Act. 3, informal release under Section 8 of the GIPA Act. And finally, the 4th access pathway, a formal application to access government information under Section 9 of the GIPA Act. These 4 pathways combine to produce a virtuous cycle of information release. Informal and proactive release go hand in hand in enhancing government efficiency and transparency in decision-making processes. The GIPA Act provides informal and proactive release pathways in order to minimise the need for formal requests for information. It promotes the timely release of information. It mandates ongoing review by agencies of their information release practices, and ensures regular and public updates of agency information holdings. Looking at mandatory proactive release more closely, we can see that it provides a core set of information from agencies that must be publicly available free of charge. For example, government contracts with the private sector, together with information reflective of major activities and risks to integrity in each sector, disclosure of interests in the local council sector, and travel in the ministerial sector. Now to the second proactive release pathway, Section 7 of the GIPA Act. This second pathway, authorised release, enables and encourages agencies to proactively release additional information, such as reports or business cases. It is this ongoing release of information that should be included in each agency's annual update of its publicly available Agency Information Guide. An AIG, Agency Information Guide, sets out all of the information the agency makes available. This information will increase year on year. Therefore, yearly reviews are required to promote currency of the information provided and to ensure that agencies are aware of the information they hold. Now we come to the third pathway, informal release of information. This pathway enables citizens to request information informally, for example, in person or during a telephone call. It also allows agencies to impose conditions on the release of information, decide the format in which information is provided, Delete information that might render the information inaccessible because of public interest considerations against disclosure. Information released informally should also be considered for proactive release to the public broadly and included in the agency's AIG. Finally, the fourth pathway, a formal access to information application under Section 9 of the GIPA Act. This pathway provides transparent and consistent procedures and timeframes for citizens making applications and agencies dealing with applications. Notices of decisions are required, and the pathway provides rights of review if a citizen is not satisfied with the agency's decision. Information released to one person through the formal release pathway should also be considered for proactive release to the public broadly, and again included in the AIG that the agency maintains. This process is facilitated by the agency's disclosure log. Now to our quiz for part 1 of this 3-part learning module. The 4 access pathways are outlined according to how they operate, and your task is to match the section of the GIPA Act with the correct description of the pathway. Give yourself a minute and see if you can match each description to the correct pathway. Write your answers down and I'll check in with you in a moment. So if you decided that Section 6 is to ensure that information is mandated as open access information and available free of charge, Section 7 is to enable agencies to release information that may have been released previously. Section 8 is to enable agencies to release information with conditions. Section 9 is to ensure that citizens have a reviewable right to access information. Then you are 100% correct. Take a few minutes and think about the key differences between the formal and informal pathways and what purpose they serve. I'll come back to you in a few moments. The 2 pathways serve different purposes. So one way to answer this question is to summarise their purpose as follows. The purpose of the informal pathway is to provide an informal and expeditious way to release information, provide information without the cost of an application, allow information to be released subject to conditions. And the purpose of the formal pathway can be summarised as to provide a robust decision-making process to determine applications for access to information. The pathway requires the provision of written reasons, and it also ensures that the decision is reviewable. In this second of the 3 parts of the learning module, we'll look at the operation of the informal pathway more closely. The informal pathway offers a lot of benefits, and by better understanding its benefits, you can maximise release and minimise effort. Firstly, it's important to understand that a single informal request for information can actually feed into a whole program that ultimately releases more information to the public. In doing so, your agency is fulfilling its obligations under the GIPA Act and also most probably decreasing the number of formal applications. Let's take some time to work through this issue of what makes informal release a program, not a single transaction. An informal release program will ensure that agencies record information that they do not make available and information that they do make available. It also ensures that agencies can better predict and manage both informal and formal requests, that they use less resources managing information access obligations, that they comply with their proactive, authorised and informal release obligations. They're more able to efficiently document their informal release decisions. They can provide access to more information and avail themselves of the protections from criminal and civil liability in the exercise of functions under the GIPA Act. They can also apply conditions or redactions to information to enable release. And they can facilitate effective ministerial decision-making through an efficient regime of open government and transparency. They're also demonstrating a commitment to openness and accountability and transparency and increasing confidence in the administration of government. There are overall cost savings for agencies operating information access in a holistically and effective manner. Informal release is a low-cost mechanism to access information, especially compared to the formal pathway. Now let's move from the big picture to the first steps you as a decision maker need to take in dealing with an informal access request. Any person can make an informal access request, and there are no legislative requirements modifying this right. However, agencies can refuse to deal with an informal access request and refuse access to information that has been requested informally under the GIPA Act. Firstly, the request should be considered, and that involves two steps. One, assess the request itself, and two, identify the information held by the agency relevant to the request. The 5 questions set out on this slide guide you in your assessment. I'll give you some time to read through the 5 questions at your own pace. Now that you've read through those 5 questions, it's now time to consider where to begin in searching for the information sought by the applicant. This image or framework that you can currently see assists you in identifying your agency's information holdings against the request. It involves 4 steps. 1, consider the information held by the agency. 2, consider the information that is proactively released. 3, look at information that could be released. And finally, consider information that may be subject to a conclusive overriding public interest against disclosure. Application of the framework will also enable you, as the decision maker, to identify what information is usually released in full or in part, free of charge or with conditions. If information has not been released because it is subject to an overriding consideration against disclosure, decision makers should consider the possibility of redaction to satisfy themselves that it cannot be released with redactions or subject to conditions. If satisfied that the considerations against disclosure override the factors in favour of disclosure, then decision makers should advise the applicant of the formal release pathway. Ensuring that consideration is given to the type of information held by the agency and the costs of release informally is essential to the effective operation of the informal release pathways. Unlike the formal release applications, conditions, deletions, different forms of access, including provisions of summaries, are all contemplated under the informal access pathway. In these circumstances, the costs to the agency and the citizen should also be considered. There is also an overall cost saving to be delivered to agencies that operate their access pathways in a holistic and therefore effective manner. Informal release is designed to achieve a low-cost mechanism for provision of information, especially in comparison to the formal access pathway. Now we will move to step 2 in assessing the information held by the agency. This step will assist you as a decision maker to make a preliminary assessment of whether the information is held by the agency and if it is suitable for release informally. It will also help you to determine if you can release the information subject to conditions, such as deleting some of the information or providing the information in a form that meets the access request. If these preliminary inquiries lead you to believe that the information is subject to an overriding public interest factor against disclosure, you should take the next step of considering conditions. Unlike the formal access application pathway, conditions, different forms of access, including the provision of summaries, are all contemplated under the informal access pathway. These options are available to enable release whilst taking into account information that may contain overriding conditions against disclosure of the information. In these circumstances, the cost to the agency and the citizen should also be considered. Government frequently compiles data and reports for internal management purposes. These reports generally take the form of business analytics reports and are regularly generated by agencies. Often, the reports are applied in aggregate in an agency's annual report. Once prepared as either an ad hoc or routine report, the agency is required to assess the information created as a possible state record. Where the report falls within this category, it will be preserved and can therefore be reproduced at little cost to the agency and the citizen. A disclosure log, as required by Section 25 of the GIPA Act, is only the starting point to examine open access information that may not be suitable for informal release. In deciding if information should be released informally, it is important to consider the types of information usually dealt with in each of the 4 access pathways. For example, open access information may still be subject to considerations against disclosure, and those considerations may be sufficient to displace the factors in favour of disclosure. However, those factors may decrease over time. It's important to consider developments in case law too. The New South Wales Civil and Administrative Tribunal, NCAT, has found that the presumption in favour of disclosure of open access information operates more persuasively to tip the balance in favour of disclosure with the passage of time. Additionally, commercial or business interests may decrease in significance over time and therefore fail to displace the factors in favour of disclosure. However, an agency cannot be required to disclose government information pursuant to an informal request and cannot be required to consider an informal request for information. We've covered a lot of information about informal release of information. Before we move on to the third and final part, let's refresh our knowledge with a few questions in this second quiz. Take your time to consider the options presented here in answering the question. Why should informal release be seen as a program? Okay, now that you've considered the options, I can share that the correct response is D, all of the above. I hope you are correct. Question 2 in this quiz is, what 2 steps should be applied when assessing the informal access request? In this learning module, we've highlighted 2 important steps, and I hope you have written them down as 1, an assessment of the request, and 2, identifying the information held by the agency relevant to the request. Now, let's move on to the final part of this e-learning module. In this part, I'll explain the practical tools that we have developed to assist you in exercising your decision-making functions under the GIPA Act, with a specific focus on informal release of information. As we have discussed today, the informal release pathway does not provide the individual seeking access with a detailed decision if information is withheld, or review rights, or strict timeframes under the GIPA Act. But agencies should inform applicants of this, and if the individual indicates they would like the opportunity for independent review if refused access to certain information or documents, the agency should inform the individual that their request may be more appropriately made and dealt with under a formal application. Recommended practice is to indicate this information in a standard template letter that can be applied by the agency. Then you have a reliable record and you are implementing good practice in administrative decision making. Now to timeframes. Unlike a formal access request made under the GIPA Act, there is no time limit for a decision and provision of access to information under the informal pathway. However, agencies are required to exercise their functions and discretions under the GIPA Act so as to facilitate and encourage promptly and at the lowest reasonable cost access to government information. Practically, agencies should advise applicants of the timeframes involved, and unless there are significant impediments beyond the control of the agency, information should be provided within the timeframes established under the formal access pathway. Consistent with the GIPA Act, agencies should actively engage with applicants to discuss an estimated timeframe for release of information, or coming to an agreement about the timeframe in which the agency will provide access. In exercising this decision-making function, you as an independent decision maker require authority to do so. The authorisation to determine an informal access request can only be provided by the principal officer of the agency. Accordingly, all frontline customer service and specialist officers dealing with informal requests will require an authorisation or delegation from the agency head. Decisions made about informal release, including the decision-making process that necessitates identification of an overriding public interest factor against disclosure of information, are decisions that impact citizens' rights, and as such, agencies should document the applications and their outcomes. The decisions should be documented to keep adequate records of agencies' activities, including decisions that are made and the reasons for those decisions, as described in the New South Wales Ombudsman Guideline, Good Conduct and Administrative Practice, which was published in 2017. Significantly, those guidelines provide that good administrative practices require documentation when information is not provided, and that documentation should set out a justification as to why it is not in the public interest to disclose that information. Additionally, State Records New South Wales advise that in order to satisfy their statutory obligations under the State Records Act 1998, New South Wales, government agencies must record all activities that are conducted electronically or face-to-face, such as making informal decisions, document the reasons for making a particular decision, file all correspondence sent or received that relates to an informal release request within the agency's electronic or paper records system. To assist agencies, the IPC has developed a suite of tools to guide improvements in the understanding of the application of the informal access pathway. They're listed here. Additionally, we have updated the GIPA tool so that you can use it to input data about informal release, and that information will also assist you in maximising the use of this low-cost and efficient pathway. The guideline should be read in conjunction with those tools. The object of the GIPA Act and good administrative practices provides sound reasons for maintaining a limited and manageable data set relevant to the informal access pathway. Adopting the cultural and process changes recommended in this e-learning module will have a profound impact on the operation of the informal access pathway and should result in a more efficient and effective information access scheme that better serves agencies and citizens alike. Now, to our final quiz. Question 1. Take a moment to think about what we have just discussed regarding documentation of decisions on informal access requests before you respond to this question. The question is, what should you document in relation to an informal access application decision? A, the date of receipt. B, the date of decision. C, communication with the applicant, such as receipt of the application and anticipated date of decision. D, the reasons for not disclosing information, if that's relevant. E, what information was not provided. And F, all of the above. I hope you all answered F to this question. The date of the receipt of the request together with the date of your decision, your communication with the applicant, reasons for not providing information, and a summary of information that was not provided are all important factors to be communicated to the applicant. And communicating these factors will ensure that you adopt recommended good administrative practice and comply with both the State Records Act, the GIPA Act, and the New South Wales Ombudsman's guidelines. Now to our final question that takes us back to the big picture. What action should you take to achieve the virtuous circle? A, consider releasing the information proactively. B, update the disclosure log. C, update the agency information guide. D, ensure that you have documented your decision together with brief reasons and timeframes. Or E, all of the above. Again, I hope you have responded all of the above. It's important that you advise the applicant of your views and advise them of their right to lodge a formal application for information so that the public interest balancing test can be undertaken and formally communicated to the applicant. Thank you for undertaking this learning module. I hope the module and the tools we have provided really assist you in maximising the use of this pathway and that you better understand the virtuous circle that is created under the GIPA Act. Remember, open government, our democracy, will survive and thrive with open information. Your work operates in the context of democracy. It is valued and appreciated. As Information Commissioner, I thank you for your contribution to this incredibly important human right.